This is Top Story, brought to you always by Telecel, connecting energies, and also by Shield Pension Trust into the future with you. Tonight, government has been hit with a fresh suit at the Supreme Court challenging the constitutionality of a Memorandum of Understanding signed between the government of Ghana and the U.S. government for the deportation of some West African nationals into Ghana. It will be recalled that the U.S. deported some 14 West African nationals into the country who were all subsequently repatriated to their home countries. At the time, this was the explanation offered by President John Mahama when he met the press.
We agreed with them that West African nationals, were acceptable because all our fellow West Africans don't need a visa to come to our country. So if they decided to travel from US to Accra, they don't need a visa anyway. So if you're bringing our colleague West Africans back, that's okay. And so I think that agreement has been activated, and a first batch of 14 nationals came. Several of them were our Nigerian brothers. They opted to go back home. And so we put them on buses, to be able to go back home. One of them was a Gambian who is not as easy. You have to get him an air ticket to be able to facilitate his travel. So what we've done is contacted their embassy to let them know of his presence so that they can facilitate his return to Gambia. And so that's the issue with regards to deportations and arrivals. West Africa has the protocol of free movement. And so any West African is free to come to Ghana and be able to stay for 90 days. And so if they decide to bring them, we don't have a problem accepting them.
But in this action before the Supreme Court, Democracy Hub, a pressure group is seeking a declaration that this MOU is entirely unconstitutional and also breaches a host of other international obligations to which the country is signed on. Kwaku Asante of our legal desk joins me in studio with some details from this particular action. Kwaku, first, what are the reliefs being sought by the Democracy Hub in this particular action?
So, Brace, I've been reporting on a lot of cases, and this is perhaps one of the longest in terms of reliefs that is being sought. A total of 28 reliefs that is being sought by Democracy Hub in this matter, with Oliver Barker-Vormawor representing the parties in court. The major ones, they are seeking a couple of declaratory reliefs that on a true and proper interpretation of Article 75 of the 1992 Constitution of Ghana, any agreement entered into by the President of the Republic to receive or facilitate the transfer of West African nationals from the USA into the Republic of Ghana constitutes an international agreement within the meaning of Article 75, and as such require prior ratification by an act of Parliament or by a resolution of Parliament supported by votes of more than one half of all MPs. A declaration, that is the second, that on a true and proper interpretation of the Constitution, the purported MOU or any similar agreement entered into between Ghana and the US for the reception, detention, or transfer of persons constitutes an international agreement within the meaning of Article 75 of the Constitution, and that not having been ratified by Parliament in accordance with Article 75(2), such an agreement is void and of no legal effect. Again, they ask for a declaration that on a true and proper interpretation of the Constitution, the transfer of involuntary repatriated West African nationals into the Republic of Ghana without first obtaining ratification of Parliament of no more than half of MPs breaches the Constitution. So they are in about three folds. The first set of reliefs is based on Article 75, and they say that the government ought to have necessarily gone to Parliament prior to effecting that MOU between Ghana and the US for Parliament to have ratified that agreement. And then they talk about how this also breaches Article 58(2) of the Constitution and the Immigration Act. Then they want a declaration that the President in this action breached the Constitution when he purported to have signed this without going to Parliament. And then they say again that there are a host of international legal obligations that this country has, that it has breached all of that simply by accepting this. And let me read this particular one, Relief 13. It says they want a declaration that the detention of involuntarily repatriated persons in deplorable, inhuman, and degrading conditions, including the refusal to take ill detainees to hospital despite the presence of an ill-equipped infirmary, and the failure to provide female hygiene products to women detainees, exposure to psychological harm, and the failure to provide female hygiene products to women detainees violates Article 15 of the 1992 Constitution and Ghana's binding obligations under international human rights law, including the UN Convention Against Torture and other cruel, inhuman, degrading treatment or punishment. It goes on and on. 28 of them that they are seeking, essentially to say that the government breached the Constitution when they sought to execute this Memorandum of Understanding with the Trump administration, the U.S. government, without first going to Parliament, and also a host of other things they did, including repatriating these persons back to their home countries without recourse to some of the legal actions and other things that he had filed.
I suppose that should be the legal argument you're making in defense of this suit, right?
Yes, so those about 28 of them released, and then they go ahead in about 30 pages to make an argument for why they believe that is so. The first leg of the argument is they rely on Article 75 and the Supreme Court decided case of Margaret Bamford, Nana Agyei, and the Attorney General. That case had to do with the Guantanamo Bay case. It will be recalled that in 2016, the same John Mahama administration signed another MOU or a note verbal with the U.S. government for some Guantanamo Bay detainees to be deported to Ghana.
The Gitmo
2 case. And then Nana Agyei, the MPP national organizer, and one Margaret Bamford went to the Supreme Court with Nana Agyei Baffuor Awuah, now MP for Menchia North, as their lawyer. They got the Supreme Court to affirm their case that matter should have gone to the Parliament of Ghana for Parliament to ratify that. And if that was not done, then that is unconstitutional. So they rely on that first leg of the case. And then they go on to say that even if the government had gone to the Parliament for ratification, the specifics of the agreement itself is unconstitutional and breaches international legal obligations of the country, for which reason, even if Parliament had ratified that, it will be unconstitutional. Let me read part of it. It says that peremptory norms of international law, also known as jus cogens, are universally recognized principles of which no derogation is permitted. These norms reflect the fundamental values of international community and include prohibitions against torture, arbitrary detention, slavery, genocide, crimes against humanity, among others. If Article 75 is construed as allowing such an agreement to be lawfully ratified, it will have the absurd consequence of allowing the executive and Parliament to contract Ghana out of its constitutional and international human rights obligation. Such an interpretation violates the basic structure of the Constitution, which is grounded in the rule of law, human dignity, and constitutionalism. Also, this interpretation will render the Constitution internally contradictory and enable the state to contract out of its core human rights obligation, an outcome that is legally and morally reprehensible. And then the last leg they make in this argument has to do with the matter having to do with non-refoulement. That these persons, having made the case that they were at a risk of being victimized in their home countries, and Ghana having accepted them from the United States of America, and then proceeded to deport them to these same countries that they had fears that they will be subject to victimization, torture, and other things, breaches Ghana's obligation to that. So they set out the case. They go on to talk about misapplication of ECOWAS protocols and other obligations that this country has, that they say all of that have been breached in this matter.
Because in the past one, we know that some of the deportees were even suing this country, in fact, in protest.
Exactly. Particularly when it comes to these deportees, they through Oliver Barker-Vormawor filed an action at the High Court seeking the court order for the court to produce the bodies for these matters to be litigated. But just before the court will hear this matter, according to lawyers for these detainees, the government just immediately transported them to the border between Ghana and Togo and just released them into Togo so that the case would have become moot at the High Court. So when this case became due to be heard, not this particular one, the one that had been filed to challenge some of the things that have been done, it had become moot because all those persons had just been taken out of the country.
Now, the CSO is also asking the Supreme Court to injunct the government from further receiving any deportees until the entire matter is dealt with.
Yes.
Do we know when this particular case will be dealt with by the court?
Yes, so if you look at the agreement, the MOU in question, which we don't have a copy of, but we've gotten certain indication of what is in it, and you hear the president talk about the first batch. So it meant that another batch may come. In fact, we are told that the agreement covers up to about 40 persons that may be deported from the U.S. to Ghana. And in particular, just last week, there was a furore about another person, Kilma Abrego Garcia, who was said to be deported into Ghana before Ghana made a case that they were not going to accept him. And then the U.S. government seemed to have backtracked on that. And so there's a second batch or third batch or more people that are expected to come in. And so while this case is pending, they are asking the Supreme Court to injunct the government from further implementing the MOU. And so the court should injunct the government from receiving any more deportees from the United States of America. And we are told by the Democracy Abuja have filed this action that on Wednesday, 22nd October 2025, the Supreme Court will hear legal arguments and make a determination as to whether or not an injunction is merited in this matter.
We can now hear from the spokesperson for Democracy Hub, Timothy Selikem Donko, who says their case is legally grounded.
Under Article 75 of the 1990 Constitution, it is clearly stated that any agreement, convention, or treaty entered into by government, either directed by the president or under the authority of the president, should undergo a process of ratification. The process of ratification is two steps. Either ratification by a resolution by more than half of members of all members of parliament or through an act of parliament. Now, the argument that this is just an MOU is neither here nor there. If you refer back sometime in 2015, there was an MOU between government and the USA concerning the transmission of some detainees from Guantanamo Bay to Ghana. That action went before the Supreme Court in the popular case known as Agyei Baffuor versus Attorney General. The court clearly indicated that the test for whether or not a thing is an agreement is an essential test. And this is a common position of the international community being held in numerous cases by the ICT. Whether or not a thing is a treaty is an issue of essence, not form. So if there's an agreement that creates a binding legal obligation on any government of any state, and it's a multilateral agreement between two or more, or a bilateral agreement between two nations, then it meets the standard of being treated as a treaty. There is what we know under international law known as the Vienna Convention on International Law of Treaties. And the Vienna Convention on Law of Treaties is very clear on what a treaty is. Any agreement of whatever description that purports to create obligation for any nation state counts as an agreement, unless it is stated in the agreement that it did not, it was not purported to have any legal obligation.
So you heard the spokesperson for Democracy Hub, Timothy Selikem Donko. The time for us to bring in Professor Appiagyei Atua. He is Professor of International Law at the University of Ghana. Prof, I'm grateful to you for joining us here. Now, as an international law professor, how do you assess the legal argument made in this particular case by Democracy Hub?
Thanks for having me, Kojo. Yes, it's a very solid case. I believe that if the Supreme Court would properly apply Ghana's international obligations as properly reflected in Articles 75, 73, 40, as well as under the provisions on human rights, it will come to a decision that the government is wrong, the decision it took is wrong, and it has violated not only the Constitution but also international laws of which Ghana is a party.
Now, we know that there are some few days before the court sits on this particular matter. What happens if these deportees land in this country before the Supreme Court hears this case?
I think that would be a serious attempt by the government to look down on the Constitution and to sell or mortgage the sovereignty of the country to another country, and in so doing clearly indicates to the people of Ghana that it takes Ghana and Ghana's laws for granted. So it will be in the interest of the government not to do the kind of gymnastics it did when it surreptitiously filled out of the country the previous bunch of deportees that were brought into the country.
But if it's indeed true that government has flouted the rules of engagement or the what the law says it must do in terms of accepting deportees, then can't anybody then cite government for breaching these rules for what it did in the earlier deportees that were brought into the country?
Yes, I think probably Democracy Hub should have continued that case. But in any case, bringing this one is timely, and it's a way of continuing that case directly or indirectly. So it is important that this particular step is taken, and so it will help cure the harm that was caused by the government attempt to dodge the legal process. And so we look forward to a positive response from the Supreme Court in this case. And we're also hoping that the government will not again do its thing by trying to smuggle in people and smuggle them out without due process.
And if they do, what remedies does citizens in the country have?
Well, I mean, we are expecting that the Supreme Court will make a declaration that the government acted wrongly and in violation of the constitutional provisions and our international obligations. So then it will clearly put the government at fault, and then it will therefore question that so-called MOU and declare it illegal. Therefore, it becomes unenforceable, and the government cannot go ahead to do anything that will violate the Constitution and the international laws, which the Supreme Court would have affirmed in this case.
There's a lot of emphasis placed on international legal obligations. How do they sit within our current constitutional architecture?
Well, Ghana is a dualist state, and that means that when we sign and ratify any international agreement, it has to come to Parliament, which represents the people of the country, to confirm that decision which is made by the executive. So that dualist process is more democratic in that it involves the people's representatives in making that decision made at the international level. So in this respect, what the government has to do is to respect the will of the people, which is expressed or is embodied in their representatives in Parliament. So Parliament will have the final say. But it's also important to note that it is not just simply asking Parliament to domesticate the international law, to make it applicable within our domestic system. But it's also about Parliament making sure that in making that decision, they take into account the other provisions of the Constitution, such as Article 73. It talks about the fact that our international affairs should be in consonance with international law. And Article 40, which talks about the fact that we should conduct our international affairs in line with the principles and objectives of international organizations like the UN, the AU, ECOWAS, and so on that we belong to. So when we look at it from that angle, Parliament is bound by certain international agreements, such as the Convention Against Torture, which Ghana is a party, and certain agreements which, including the Refugee Convention, which the principle of non-refoulement, which says that you cannot deport somebody to a country where the person might have already suffered torture, and taking the person back there would lead to a continuation of that torture, or even where the person is afraid and there's reasonable grounds to conclude that torture has been taking place in that place. So taking the person there will result in the person being tortured. That means that the government, Parliament will have to take into account all these obligations that Ghana has, that as a member of the international community, there are certain laws which as international laws may override the local laws, or we have to make our laws reflect and conform to those international obligations. So that would be the final determinant or the basis for Parliament to rule or to make a decision as to whether the MOU should be ratified or made domesticated and made part of Ghana's laws.
I'm grateful to you, Prof. Professor Kojo Appiagyei Atua is Professor of International Law at the University of Ghana. Let me bring in now Nana Agyei Baffuor Awuah. He is MP, Menchia South, and member of the Constitutional Affairs Committee, and also serves as the Vice Chair of the Subsidiary Legislation Committee of Parliament. Grateful to you, sir, for joining. Now, do I have you?
Yes, please. Thank you very mumuch.
Now you led Margaret Bamford and Nana B to the Supreme Court on similar matter during the Gitmo 2 case. Do you see similarities in your argument in this particular case?
Thank you very much. It's commendable that we take steps to oftentimes protect the Constitution from being breached by persons who serve in public office. And so in that regard, I commend everyone that would take such a step. The fundamental question that we have to ask in this particular case is whether the present action indeed raises or properly invokes the jurisdiction of the Supreme Court. It is my humble view that this particular process will have a major procedural hurdle to scale. What is the procedural hurdle? The procedural hurdle is whether the Supreme Court, having interpreted Article 75 in Margaret Bamford, would want to interpret it again. We should not forget that the Supreme Court interprets provisions of the Constitution and not conduct. And so, having interpreted the provisions of Article 73, 75 in Margaret Bamford, it is not up for interpretation again. And so, why the need to go to the Supreme Court? What is now outstanding is enforcement.
So what should have been the appropriate action?
The appropriate action should have been to go to the High Court to enforce the provisions of Article 75 in the light of the conduct of the government, which, in their view, or in the view of the general public, is contrary to Article 75. Article 75 doesn't need interpretation again.
So you're saying that we should expect that the Supreme Court may say it won't go into the matter again because it has sat on it?
I'll be very surprised if the Supreme Court entertains this action. I'll be very surprised. But you see, I would not be shocked because in recent times, certain things have proven that the Supreme Court, very respectfully, remains unpredictable. But if you look at the chain of authorities available, once the court interprets a provision of the Constitution, that provision very respectfully becomes clear. There's no dispute regarding that provision. And so if you consider that there has been a breach, then you go for enforcement at the High Court because now it is clear.
It would have worked if they were going for a review of that decision.
No,
is that what you're saying?
There's no review. You can't review. You can't go for a review of a decision of the court in respect of a different matter, right? In application to a different set of facts. No, but
are these different set of facts? And they similar?
This is not Margaret Bamford versus Attorney General.
Okay.
And so you can't go for a review of the ruling in Margaret Bamford versus Attorney General. They are different matters altogether. And so this is the procedural, but I'm not surprised. I won't be surprised, right? I'll be, let me see, for want of a better word, I will not be surprised if the Supreme Court entertains it, but I'll be shocked. That would reinforce the view that the dominant view in recent years that our court has become so inconsistent and unpredictable.
But what if the Supreme Court uses the opportunity to reaffirm its stance in that Margaret Bamford case?
To be reaffirmed. There's nothing to be reaffirmed. the Supreme Court has laid a provision of the Constitution, it doesn't need to drum it further or louder. That it is clear, Article 75, right? And what amounts to an agreement in there, right, is even clear, okay? And so it doesn't matter the nomenclature, it doesn't matter the coloration, right? Once the Supreme Court has interpreted it, Article 75 is clear. It doesn't need interpretation again.
So before the Supreme Court is yet to call the matter, is there any remedy for the people who took this matter to the Supreme Court?
You go to the High Court for enforcement. Largely, it's a human rights action. It's a human rights action which had been predicated on Article 75. If Article 75 had not been interpreted, they would have gone to the Supreme Court. But once Article 75 has been interpreted, then you go to the Human Rights Court to say that on the basis of the Supreme Court interpretation, right, among other things, your client's right is being infringed upon. And so there is a major procedural hurdle.
Okay. You are a member of the Constitutional and Legal Affairs Committee of Parliament. The Foreign Affairs Minister has explained that this was an MOU that did not require parliamentary approval. Is that not a fair argument for one to make?
It is not. You see, you have to interpret the provision of the Constitution. The question is whether or not, right, to the extent that it is an MOU, it does not fall within Article 75. If that is the question, we have to go to the Agyei Baffuor case to ascertain whether the Supreme Court, in interpreting an agreement there, right, interpreted same to include MOU. In any event, the word MOU is being used loosely. An MOU, right, it's not what makes an MOU. It's not the title MOU. It is the terms and conditions thereof. Okay, the terms and conditions, once they place an obligation and create a right, goes beyond an MOU. An MOU doesn't create a condition, doesn't create an obligation, and doesn't create a right. Okay, and so we have to look at it very carefully. It is the content that matters. What is So it is not the MOU that is being sent to the Supreme Court for interpretation. It is the provision of Article 75, which is up for interpretation. The Supreme Court has already interpreted it. It can't keep interpreting it. Look, the Constitution,
but if the minister says,
please, if you may bear with me,
okay,
indulge me. The Constitution is the manual by which public affairs are conducted. Okay, and so if the Supreme Court is going to say one thing in the morning, right, about a particular provision, and say another thing in the afternoon, it is going to reinforce the general perception of inconsistencies of the Supreme Court. In any event, yes, we agree that the Supreme Court can depart from its decision, but its previous decision. But in respect of the interpretation of the Constitution, right, the Supreme Court cannot constantly be departing. Otherwise, there will be no certainty. There will be lack of predictability.
But it is not your expectation that the Supreme Court will depart from its initial ruling, right?
First and foremost, you must create a question for interpretation. That question doesn't exist.
In this particular
it doesn't exist.
It doesn't exist. In this particular case?
No, it doesn't. Because you are seeking a declaration. That declaration has already been made by the Supreme Court in the case of Agyei Baffuor.
So yours is that outrightly the government was wrong to have accepted this MOU without recourse to Parliament.
So you go to, it's not that they don't have a relief. Once the Supreme Court has laid down that declaration, your relief, you go to the High Court. That is your venue.
Okay. All right. I'm grateful to you, Nana Baffuor Awuah, for joining us here. He is MP for Mensah South and a member of the Constitutional and Legal Affairs Committee of Parliament, and also as a Vice Chair of the Subsidiary Legislation Committee. This has been Top Story, brought to you by Telecel and also Shield Pension Trust. Up next is Newsnight.